Good evening. This is Rahul Reddy. We're live here from Houston, Texas, every Tuesday from 5 p.m. to 6 p.m. Central Time. Reddy Neumann Brown does bring in immigration updates, and we take live questions from audiences at this point of time. Along with me is my business partner, Rebecca Chen. Rebecca, what do we have today to discuss?
Yeah, so we'll talk about the State Department's recent announcements about the using up of the employment-based green cards for this fiscal year in a couple of categories and what we anticipate that means for the rest of the employment-based green cards for the rest of this fiscal year, which is just until the end of this month. We'll also talk about how H4 visa holders who are by default not authorized to work, how you can put yourself in a position to be work authorized and get a work visa or a work permit. We'll also talk about advanced parole, whether you are able to travel while your I-131 advanced parole application is pending. In what situations can you travel, and in what situations will it result in a denial of the I-131? And finally, we'll talk about strategies for handling extended PERM processing delays. Processing times are still at about the 13-month mark from what we're observing recently. So what can people do if they are nearing their 6-year limit and are looking for options to ensure they don't have a work authorization gap due to a PERM processing delay? So first of all, for the 2024 fiscal year green cards, Rahul, what is the State Department announced and what are we anticipating for the rest of this month?
First, I want to tell all audiences that fiscal year for the immigration ends on September 30th. So it's not December 31st, but it's September 30th. The fiscal year ends. It starts on October 1st, ends on September 30th. Now, as we know, that employment-based has 140,000 green cards, and anything that has been not used up for the family-based in the previous fiscal year will be falling into this year. Fortunately, for employment-based green cards, we have approximately around 21 or 23,000 extra green cards that fell into the lap of the employment-based green cards. Now, we have seen that in fiscal year 2021, that starts on October 1st, of 2020, ended on September 30th of 2021, they did wasted a lot of green cards. Approximately more than 50,000 green cards were being wasted because they didn't work on it. Yeah. When it comes to the fiscal year 2022, they did very efficiently. They used up all the green cards, all the excess green cards that came from the family base. They did use the green cards, and also in fiscal year 2023, also they did use almost all the green cards that have been allocated. In fiscal year 2024, which in fiscal year 2023, we had like 40,000 extra green cards over and above the 140,000 green cards that were being used in fiscal year 2024, which is ending in September 30th. They have extra 23,000 green cards, but the way the State Department is going looks like they're going to use each and every number. They're already done with EB3, they're done with EB5 categories, and the certain categories they're done with EB1. So only seems that EB2 category may have been left over if there is anything left out. So, and the way that they are adjudicating the applications, I'm pretty sure that they're going to use up the EB2 green cards. That means that they may complete the entire 140,000 plus approximately around 20,000+ that have been fall into the lap of the employment base. Bravo, USCIS, good job that you could not wasted any green cards for the employment base. Thank you for doing it. Any other things on that, Rebecca? What do you anticipate next year? Will there be any, every year in fiscal year 2021, we have a lot of green cards that fell into the lap of the employment. And then in fiscal year 2022, of course, 23, it went down to 30 plus 35,000 or 40,000. In fiscal year 2024, we had still 20,000 extra green cards. Do you anticipate that the family immigration is not used up their quota, and then we're going to have some excess coming up in fiscal year 2025, Rebecca?
It's hard to say. We're not really anticipating, definitely not anticipating a large spillover. I think we were a bit surprised that there was the amount of spillover there was for this current fiscal year that we're in now. The reason why there has been spillover in the past was mainly a function of the COVID pandemic that shut down consulates worldwide. Most family-based green cards are issued through consulates, and when the consulates were shut down, people couldn't attend their green card interviews and get the family-based green cards there, and so there was spillover into employment-based, where most of the green cards can be used because the majority are adjustment status based applications. Now that COVID is mostly a thing of the past and consulates are for the most part back to pre-COVID operations, we're expecting that there won't be as much, definitely not as much, and possibly no spillover going forward, barring some other situation that would disrupt consulates or family-based visa processing. We also want to mention, what does this mean for I-485 applicants if you have, for example, a pending EB2 application or a pending EB1 application? What does that mean for you right now that USCIS has used up the EB1 green cards that it has for this year? Your application still remains pending. It just means that you won't get a decision on it before September 30th because they can't issue any approvals in EB1 or EB3 for the rest of this month. But your application is still pending, and hopefully if your party date is still current in October, your application could be approved then if it's completed processing. For people who are preparing to file I-485 applications in the EB1 or 3 categories, you can still do so. USCIS hasn't made those categories unavailable in the visa bulletin, even though they've said that they've used up the green cards. That means you can still prepare and file your EB1 or EB3 I-485 application if your priority date is current, according to the September visa bulletin. They'll still intake it, but of course they can't approve anything until there are green cards available in the next fiscal year.
Let's go to the next topic, Rebecca. This is a very close, dear topic because I came to United States on H4 visa. Even though I had a license to practice as an immigration lawyer, I couldn't do it because I was not having a work permit at that point of time when I was on H4. So it was hard that I had to face all those difficulties. Now, situation is quite different than those people that came like me a long time ago. Right now, they have multiple options of getting the employment authorization. Now, of course, the people who come in H4 has an option of applying the H1B and getting the H1B option. They can apply for the F1 and convert into F1, and then later on get into OPT and STEM extension that's available. There's also, if the priority date, one thing that I don't want anybody to neglect, which most people do it, is that have your spouse file a labor and I-140 as soon as possible. And if the company is not filing the labor and I-140, tell the spouse, move on to a different company that can file the labor and I-140. And if the spouse says, no, the market conditions are not good, I would just tell, update the skills so that you can get the proper company to, because if your skill set is demand, then you will have the employers ready to file a labor and I-140. So make sure that you have this, your spouse file a labor and I-140, because the options of getting the H1B, it's a lottery and it's very hard because when you don't have a job, it's very hard to find an employer to file a H1B application. And also to get F1 OPT, it's definitely a long route. It takes 2 years to complete the degree, getting the admission, completing the degree, and then you get a EAD that is riddled with a lot of conditions. You can't have unemployment period. You can't have, in the STEM extension, you have to have a paid internship. So there are a lot of difficulties at this. H4 EAD is really a good option that you should consider. And a lot of people, as soon as you step into the country, I'm not telling you not to venture around to try to look into H1B or F1, but also please do not neglect the H4 EAD. It is really so easy to get H4 EAD, no conditions attached. You can work for any employer, no geographical limitation. You can work as an intern. You can flip a burger in McDonald's. You can be a Microsoft CEO. You can be a lawyer like me, and you can be a doctor. Any of those things are possible on H4 EAD. So it's easier if you can get your spouse file a labor and I-140, and once that is done, then it's heaven for you. From there, it's easy to navigate. Now, of course, you do have an option of the you can file if you're eligible for EB-1A green card also, you can still file it, even though you are an H4. And there are some people who are like PhDs coming into this country with exceptional, extraordinary skills, though. While the spouse is not filing an I-140, can the H4 EAD file an I-140? Those options are also there too, that you may explore if you think so, you're eligible for. But the number one thing, what I see most of the H4 EAD, H4 persons do get employed is H4 EAD. The easiest way is to get your spouse file an I-140. Do not neglect it. Anything else, Rebecca, before we go to the next topic?
No.
Now, Rebecca, let me ask you this question, though. I'm filing my I-485 application right now. Along with that, I file an advance parole. And while the advance parole is pending, if I travel outside the country, will they deny my advance parole?
Yes, they can. So if you file an I-131 application and you leave the U.S. without an already valid advance parole document, USCIS considers that you have abandoned that I-131 application, and according to their policy, at least, they will deny the I-131. And we have seen those types of denials. We have occasionally seen situations where the advance parole still gets approved in that situation, where someone wasn't aware of the policy and traveled, and the I-131 was approved and the advance parole was issued. Technically, USCIS has said that you're not supposed to get the advance parole in that situation, and they're supposed to deny it. Pretty much the only situation where you can travel on travel while an I-131 is pending is if you already have a valid advance parole in hand and it's a renewal application that's pending. If you go while the advance parole is valid and come back while the advance parole is valid, the I-131 application can continue processing. It won't be denied. But as far as USCIS's policy, that's the only situation where you can travel with an I-131 pending.
What if I have an H1B approval? And I have a H1B stamping? Can I travel? Will it be any difficulty in traveling, though?
So you won't have problems leaving the country or returning to the U.S. if you are on an H1B and have the H1B visa in your passport. And traveling in that situation also preserves your I-485 from being abandoned, but it does not preserve your I-131 from abandonment. So in that situation, even if you leave with valid H1B status and come back in valid H1B status, if you don't already have an approved advance parole in hand, the I-131 will likely be denied. Although that is you can still have your I-485 continue processing. So your I-485, in order to not be considered abandoned, if you don't have an advance parole in hand, you have to leave and come back in valid H or L status in order to not abandon the I-485.
Can I go for H1Bs or stamping there? I have an H1B approval. Will that be a problem because I have an 485 pending?
No, you won't have any problems getting the H1B visa stamp as a result of the I-485 being pending. So the H and L visas are some of the only visas that allow for dual intent. You're allowed to have the green card process ongoing and still get the H or L visa.
What if, well, I forgot one thing. What about the EAD though? You said advance parole will be denied. What about the EAD that I filed with the 485? Will it be denied because I left the country and come back on H1B?
No. So I-765 applications will remain pending whether you travel with a valid advance parole or H or L status. Basically, EAD applications, I-765 applications are unaffected by any type of travel. They can continue processing.
Anything else, Rebecca, before we go to the next topic?
No.
PERM applications are taking about 13 months nowadays to get them adjudicated. A lot of people have these questions that, hey, you know, I'm getting now near my 6-year extension. Is that a problem? Well, you guys need to understand one thing, that if the PERM is pending for 1 year, you can apply for the 7th year of H1B. Now, you can't apply for 3 years H1B extension. You can apply for 1 year extension. And if you have a spouse, you can apply for their H4 plus EAD along with the H1B extension. Now, so that resolves the main problem. And because now everybody is prepared that it's going to take 1+ year for you to get the labor approval. Now, there are situations where even if the labor is not been pending for 1 year, you can still apply for the 7th year extension. Yes, that is true. Let's say, for example, if your H1B is expiring in February of 2025, and your labor has been filed in December of 2023. So that means that by the time it is December of 2024, it will be 1 year. Can you file the extension in September of 2024 to request the H1B from January of 2025 to January of 2026? Because your PERM would have been pending by December of 2024. The answer is yes, you can. Now, there are some situations where people have their H1B even expiring. Let's say, for example, their H1B is expiring in November of 2024, okay, November of 2024, and you file the PERM in December of 2023. You can still file the H1B extension from November of 2024 all the way to January of 2026. People do forget it that they can file, because as long as the PERM labor would have been pending for 1 year, by the time your entire 6th year is going to be complete, you don't have to wait for the 1 year completion of the PERM labor to file the 7th year extension. There are some lawyers that are confused. You can show an article that I've written in the rnlawgroup.com. Tell them you can file way before that. And if you have any questions, you can consult us. I will give them a very clear answer how they can file the H1B extension, even though the labor has not yet been pending, but for 1 year, but would have been pending by the time your 6th year H1B expires. Now, if you're coming very close to 6th year and you don't have enough 6 years, so there are some alternatives. Consult me or Rebecca will tell you. For example, you may have to spend some time extra outside the country. You may want to convert into B2. You may want to convert into F1. If you have H4 option, you can convert into H4. And once the labor is complete the 1 year, now you can come back to H1B at any point of time without going through the lottery system. So there are many exceptions available. You need to avail, but don't come to us. I am 6th year is ending. My 6th year is ending on September 4th, 2024. Now help me, Rahul. No, please don't do that. Please don't do that. Try to contact us well in advance, at least 6 months or 7 months in advance. We can sort out a different plan based on your company needs, though. Sometimes your company may not be cooperative. Sometimes your company may want you to continue working. Maybe they want you to go to India and work at that point of time. So there are a lot of custom-made things that we have to do it for you. So please contact an immigration lawyer 6 months or 7 months in advance, not 1 month in advance. Obviously, for those people who are contemplating and filing the green card application and extending their H1B, we know that for most of the Indians, the EB2 and EB3, you're not going to get the green card. We all know that. But you still need the PERM labor and I-140 approval so that you can get the H1B extension beyond 6 years, so that you can get your spouse H4 EAD. You still need it, and try to apply for the green card as soon as possible. And if you are entering into 2nd year and you haven't started up the H1B and you haven't started the green card, you are in the danger zone, real danger zone. You need to sit down and clarify what is your path for you to get beyond 6 years. Believe me, time just passes so quickly. Even though we told that it's taking only 13 months to get the PERM approval, the entire process of filing the PERM from the beginning of the advertisement to filing the labor certification may take up to 1 year, just to file an application. You may ask the question, does Reddy Neumann P.C. just sleep on the application? No, we don't. First, we have to file the prevailing wage. There is a recruitment process. That all needs to be done before we file the thing. For example, H1B, we can file it in 1 week. We can file the LCA and prepare all the documentation, send to the employer, come back. And by the time LCA comes in, we can file the application in 1 week. Not true if we are starting the PERM labor certification from the scratch. Now, that is us. And you know, these big law firms, these big companies, the giant companies, they take a lot more than 2 years to get the entire process done. So be prepared. Now, we are already assuming that the company is going to file an I-140 and premium processing. That's a different aspect. But still, just to get the labor certification, it may take anywhere between 1.5 to 2 years, depending on the company and a lot of different things. Anything else, Rebecca?
Another thing that you can consider is, which we have had some consultations on recently due to layoffs in certain industries. Your company may have started the PERM process for you or agreed to, and maybe it was underway, but they had to stop because there were layoffs at the company. And the way the PERM program works is that if a company has layoffs in a position that is substantially similar to the one that they were sponsoring you for, they legally cannot continue with your PERM for a certain amount of time. And so that, it may be, it's out of your control, and it may even be out of your company's control, the PERM being processed on time. In those situations, probably if you are really getting close to to approaching the 6th year, something that some people have done that is helpful is consider the NIW or EB1A, some of these self-petition options that don't require company sponsorship and that don't require you to go through DOL with the PERM process. You basically, once your application is prepared, you just file the I-140 directly, and the filing of that I-140 is essentially the same as filing a PERM. And the I-140 receipt, if it is filed before you enter the 6th year of your H-1B status, can also serve to extend your H-1B for that 1 year, that 7th year that Rahul mentioned. So definitely, if you find yourself in this situation and you think there aren't many options, consult with an attorney and see if there are other creative options out there to get your H-1B extended.
Let's go to the questions, Rebecca. Questions from Dolly. What's the guesstimates on October bulletin? Hey, that's going to be tough. We're going to try to see if we can get Charlie Oppenham as a guest of Reddy Neumann Brown. We'll try to see if we can try to get him as a guest. After your request, Dolly, I already passed on the message. We'll get in touch with Charlie Oppenham. He's the one who have done the visa bulletin up and down for 30 years. So let's see if I can get him as a guest and see what he's going to say, because he knows much better than we all do.
There are a couple of questions asking for an update on the domestic visa stamping program. We haven't heard anything further from the State Department on that beyond the pilot program that they did earlier this year that seemed to go pretty smoothly. I mean, it was for a very limited subset of people that did the pilot program of the domestic visa stamping, but those that did seem to go through it successfully without issues. So we are hoping that the State Department will announce an expanded rollout soon of that, but at this time, no further updates.
Kushbu has this question. She is a licensed physical therapist, have a multiple job offers. Can she apply H1B lottery from all the employers? Yeah, you can. I mean, but I would be a little bit more cautious though with the demand in physical therapy, because I know my wife, she gets a job opportunity every 3 miles that she crosses from the home. She gets a job opportunity because she's a physical therapist. So it doesn't mean that you go to all these employers, have everybody file the H1B lottery, because then the USCIS will get some suspicion. They don't understand why you're doing. And technically right now, filing with 20 companies doesn't give you any advantage, because you still are counted as Kushbi as one. So I would recommend though, that you file maybe 2 or 3 employers at the most, and that too with a genuine job opportunity, not if there is anything fake or anything involved in it. Don't. If it's a genuine job opportunity, which for most physical therapists I see that, because I know my wife can get a job like 3 miles from anywhere in Houston. That's very surprising, the kind of job opportunities that they have. Yeah, you can.
Rakesh has an expired H4 visa stamp changed to H1B status in the US and is asking, can he travel to Canada and use automatic revalidation to come back to the US on H1B status? Yes, you can. So that is the situation where you can travel to Canada or Mexico for a period of 30 days or less, and you can return to the US with an expired visa in your passport, as long as you have the I-797 approval notice with the I-94 attachment at the bottom, they will basically automatically revalidate your visa at the border and allow you to enter the US with that expired passport visa, even if it's for a different visa type. So it's fine if it's an old H4 visa. Yes, you can automatically revalidate.
Ranyan has this question. He is waiting for the advanced parole. Can he go outside the country? He needs to join a college outside the United States. And can he come back on a visitor visa? Absolutely not. You should consult a lawyer. There are ways to expedite the advanced parole. You may want to sue the USCIS. You can contact Stephen Brown in our office. That's one idea that you can have. But if you have filed a 485 and you're trying to come back on a visiting visa first, you're considered to have abandoned the 485 application. Second, because you already filed the green card application before, you have to prove to the satisfaction of the consular officer that you're going to go back to your home country once you have completed your visiting visa. But since you already filed the green card before, then you are a big suspect, very good chance that your B2 or visiting visa will be denied.
Tony Roy has a question related to what we were discussing at the top about the use of the EB1 green cards for this year. He has a pending I-485 in the EB1C category. It sounds like the priority date is current, but he received the message from USCIS that they are pausing processing because of visa unavailability, and he wants to know what's next. So in your situation, what that means is you definitely won't get an approval on your I-485 before the end of this month. But it doesn't affect your overall I-485 application. It remains pending. If there's still processing that USCIS has to do on it, like the background checks or reviewing the medical exam, they will still continue doing that. It doesn't mean that they have closed your case altogether. It just means that they can't issue a final decision until a green card is available in the EB1 category, which won't happen until October 2024 at the earliest.
Sunny says, can I go to Canada and Mexico for H1B stamping and return to United States even if they issue 221G? Absolutely not. You cannot do that. Ranyan is saying that he requested for advance parole expedited, they denied it. We are telling to sue the USCIS, not expedite though. That's not what you should be doing. Deepu has a very interesting question. That if somebody comes on L1 visa, do the company has to file an I-140 within 3 years after they enter into United States, or can they file the I-140 afterwards? She's speaking about EB1C I-140. Now, Deepu, here is one thing careful. Let's say you're working for company A, okay? And you are coming into United States to work for company A, okay? And you're continuing working for the same company A, the company A in India and the same company A here. Let's say Cognizant in India, Cognizant here in United States. Does Cognizant need to file an I-140 within 3 years? The answer is no. They can file it afterwards. Now, if you are worked in Cognizant in India, now you're working as Microsoft here. And after Microsoft, you move back to Cognizant. Can Cognizant file the I-140 after 3 years? The answer is straightly no. The reason is that you must complete within the past within the past 3 years, you must have worked for the company for at least 1 year. So there is a problem there because you are not working for Cognizant when you're here in the country. So that 3 years is a little bit shaky thing. That means that if you work for Cognizant, after coming into the United States, Cognizant can file the I-140 after 3 years. But if you left the Cognizant though, and then you work for some other company, you come back to Cognizant, there is a problem. They cannot file an I-140. That's the thing that you need to learn.
Abhishek is also asking about EB1Cs. He's asking, are we seeing a lot of RFEs on EB1C I-140s? Personally, I am not. for the most part, our EB1C I-140s are going through without many RFEs or any.
Rebecca, as compared to previously, like 7, 8 years ago, or 5, 6 years ago to right now, things are more easier in EB1C. Don't you think so?
I feel like it is. You still have to document everything very well. Make sure you have documentation of the managerial duties. USCIS does want to see corroboration. It's not enough to say that you were a manager in India 5 years ago. They do want to see some sort of documents proving that you were a manager in India 5 years ago, which sometimes that's the challenging thing to get is copies of performance reviews that you signed off on 5 or 6 years ago, or other emails that you've sent before that prove that you were a manager. So that's sometimes the challenge. But if you have those documents, can find those documents and compile them and be very clear with the positions in both countries, who your direct reports are, what your relationship was to them, and have corroborating evidence to back it up. We haven't seen much pushback, many RFEs for the EB1C petitions, really. I think the category that seemed to get the most RFEs as of late seems to be the EB2 NIW, specifically the ones that are filed in premium processing. That is what we have heard from our colleagues, Kareem Giovanni, who files a lot of NIW applications. USCIS, especially the premium processing unit, seems to be issuing RFEs as a matter of fact for any NIW filed in premium processing, possibly as a way just to buy themselves more time if they're getting a lot of applications. But that is where we seem to be seeing more sort of unreasonable RFEs recently.
Okay, let's look into. Can my wife carry the H1B amendment? I'm assuming that it's been approved, and get a H4 stamping until 2026, even though her old H4 visa is stamped until April 2025? The answer to Avish is yes, they can. Absolutely. I don't see any problem whatsoever at all. In fact, though, even though she has a stamping until April 2025, she can come into United States with April 2025, and then she can show your H1B approval, and they could give H1B until H4 until 2026. They could, and that she has to show very clearly, and she has to get it.
PERM has a pending I-485 application in the EB3 category, party date in 2012, and he is estimating that his party date will be current in October 2024. And he wants to know, when is he going to be able to raise a service request with USCIS to get them to move on the application? Does the party date have to be current according to the final action dates, or just the dates for filing chart? So typically we recommend waiting until your party date is current according to the final action date chart in order to raise a service request or take other steps to prod USCIS to move on your I-485 application, because under the dates for filing chart, technically they can't approve an I-485 if your party date is current only according to that chart B. The dates for filing chart is a chart to allow people to file applications so that they can start intaking applications, start on the processing of the background checks, medical exams, all of that. So that theoretically, the 6 to 12 months later, when their date is estimated to be current in the final action dates chart, it's ready to approve. So they can't issue a final approval on anything until your party date is current in the final action dates chart. So we would wait until then to raise a service request or take even other steps such as litigation.
Okay, 1 second. Laid off while 485 is pending, what are the options? It may end up in denying the 485. You can be self-employed, you can try to get a job offer, you can go to consulting company, get a job offer, but if you are unemployed, you can't get any job offer and you cannot employ yourself, or your wife doesn't want to employ you in the similar field, then your 485 could be denied. I would definitely recommend that you contact an immigration lawyer as soon as possible to look into all other options available. And one thing is that, is there a 60-day grace period that's allowed in the H1B for the 485? There may not be. a 60-day period that's left out for you.
MK says that his H1B was applied online and his dependent's H4 was applied through the mail. Is there any chance that they will get approved at the same time? Unfortunately, probably not. Yeah, for whatever reason, USCIS rolled out this new online filing system for H1B applications earlier this year, but it does not yet have the functionality to concurrently file an H4 and EAD application along with it online. So that is one of the big disadvantages to filing the H1B online, is that your spouse's H4 and EAD applications won't be approved concurrently in that situation. And so they will, even if your H1B gets approved in premium processing, the H4 and EAD likely will be pending for 4 to 6 months.
Runyon, still, you cannot enter into visa waiver program because you already filed a 485 application. That is not the way to enter into United States. You need to contact an immigration lawyer. Ashwin is asking the question, I'm traveling to India to get the H1B stamping. When they come back, can I say that my only purpose for the visit is for stamping? No, Ashwin, that is not the answer. You're mistaking the question that they're asking. They're asking, what's the purpose you are coming into United States? The purpose you're coming into United States is work for company X that got the H1B. Well, I wouldn't say X now is a company. Now, company A. So the company A got the H1B. The purpose of the visit they're asking is not your visit to India. They're asking your visit to United States. The purpose for you to United States, the sole purpose for you to United States is absolutely to work for the company that filed the H1B that got the stamping. So don't tell why you went to India. Tell them why you are coming into United States. Question from Jai Garvi, Gujarat. Now, 490A, that may become an issue because it's a felony crime according to the US standards. So it needs to be handled very carefully. You can contact immigration lawyers. I'm a licensed lawyer in both United States and India. Or you can contact Indian lawyer who's a little bit more familiar with what a 498 case in India is. Of course, I am assuming that you already have an a criminal lawyer that is handling the case in India. Don't try to hire lawyers in United States. For the criminal, you need to have a criminal lawyer in India, but on the side of it, try to speak with an immigration lawyer who has both licenses in India and in US. I am one of them.
Ramu's H1B was selected in the lottery this year. It sounds like it's approved, but unfortunately he is being laid off and his employer is going to withdraw his H1B. And so he's asking, can his H1B still be transferred? So it depends on the timing of the withdrawal of the H1B approval by your current employer. If they withdraw it on or after October 1st, you can still transfer that H1B to a new employer if you are able to find, and you technically have the 60-day grace period. So if your H1B was approved as a change of status and you remain in the US, it will, and it is not withdrawn through September 30th, then on October 1st, your status will automatically change from F1 to H1B. And even if your employment terminates on October 1st, that's fine. Your employer can withdraw the H1B on October 1st. You get the 60-day grace period and you can have an H1B transfer filed within those 60 days. If your employer withdraws the H1B before October 1st, unfortunately, you will lose that H1B lottery selection because if it's withdrawn before it goes into effect, then you cannot transfer that H1B. Your STEM PT should still be valid. So if you have time left on your EAD, you can continue working for a different company, but you may need them to re-register you in the lottery next year.
My spouse has a H1B from a nonprofit organization, has an I-140 from the same nonprofit organization, which is CAP exempt. I'm an H4. When I get based on the EAD, now can I work for a for-profit organization because I have an H4 EAD? through a spouse who is working with a nonprofit organization who is a cap exempt and got the I-140 with the same company? The answer is absolutely you can work wherever you want to. You can work for McDonald's flipping a burger. You can be a Microsoft CEO. You can even work for a nonprofit organization. You don't have any restriction. Even though your spouse is working for a nonprofit, got the I-140 for nonprofit, even though your spouse is H1B cap exempt because of the company status, you on H4 EAD can do whatever you want to. You can work in McDonald's, you can be a lawyer, doctor, engineer, rocket scientist, or you can be Satya Nadella. Well, not exactly Satya Nadella, but Microsoft CEO.
Sarmad has a priority date, and he's asking if the priority date from company A becomes current while he's at company B, will the priority date expire after 1 year while he's PERM is being processed through company B? So I think you might be thinking of the rule where if your priority date becomes current according to the final action dates chart, then you cannot get further 3-year extensions of your H1B status unless your I-485 application is filed within 1 year of your priority date becoming current. So it's not that your priority date expires. Actually, your priority date never expires. If it's 10 years later from when your priority date first became current, and then you want to file an I-485 based on it, you can at any time. Your priority date never expires. It's just that for purposes of the H1B extension, you may not be able to get further extensions of your H1B status based on an approved I-140 if your priority date is current according to the final action dates chart. So that's one thing that you kind of need to look out for and maybe time carefully the filing of the H1B extension. For example, if you think your priority date is going to be current soon according to the final action dates chart, maybe go ahead and file a 3-year H1B extension while your priority date is only current according to the dates for filing chart. So dates for filing is not considered current for purposes of the H1B application. So maybe file an early H1B extension for 3 years, and then, while it's only in the dates for filing chart, so that when it moves into the final action dates chart, you're not at risk of your H1B expiring anytime soon.
Question that is coming from Kotesh, the H1B 60-day grace period, when does it end? How, if we just file the H1B transfer, it ends? If we get a receipt notice, it ends? Or do we have to start employment? The answer is must be filed, must be employed also. It's not like you file the H1B transfer application and you start working after 6 months. No, that's 60 days plus 6 months, that's not allowed. Within 60 days, you have to work. Now, you have to get the receipt notice. Now, technically speaking about once the USCIS receives the FedEx though, that's a confirmation that USCIS received. Based on the FedEx tracking number, you can start working. So it's the 60 by 60 a day, you have to start working. That is the technical rule. This question is coming from Surendra Gotipati. Will there be a ban on the people who have committed multiple H1B filings? Yes, we have seen cases where, especially when people go for stamping, they've been questioned about it, and they have been issued a ban for ever coming back into the United States. Normally, there are cases where they got revoked their H1Bs because they filed multiple H1Bs. Sometimes they got denied. Sometimes after the approval, they got their H1B revoked. But for those people who are going to stamping is where we see a lot of problem. They take these people to a small room, put them there for 1 hour, and they question very much their involvement in the multiple filings. So if you have been involved in multiple filings, we strongly suggest you speak with a lawyer. Try to look into your options. So if you're being taken into that room, what would they ask? Now, if your involvement is there, then there is a chance they may empower you. If you don't know that your company has filed multiple H1Bs, you just were working for that particular company and they took the information, gave it to multiple other companies to file, then you have to articulate that very clear to the consular officer, saying that it was not you who did it, it was the employer who did it, that ended up into this one. and then you should be able to get the visa stamping there. Otherwise, if you don't articulate it properly, though, at the time when you go to the consulate, they may bar you for ever coming into the United States. But overall, anybody who has been involved in the multiple filings, we strongly recommend that you contact a lawyer and speak with, so that you can get to know the options.
The African foodie has an I-485 that was filed in the EB1A category about a month and a half ago. He's done the biometrics, and his party date is current, and wants to know whether the green card quota being used up affects his adjustment of status. No, it doesn't. So there's no reason to worry about your pending application. Processing will continue. They still did your biometrics, and they'll continue the processing on that. Typically, I would say an I-485 application where the party date is current the whole time still takes probably a minimum of about 6 months to be processed. Anywhere between 6 to 12 months is pretty normal. So in your case, it really doesn't, the green card quota being used up for this fiscal year doesn't affect your case at all, because I wouldn't have expected your I-485 to be ready for approval by September 30th anyway. So it will hopefully get approved, by the end of this year or early next year, when green card numbers are available in your category.
I'm an L1 visa. This comes from Rohit Singh, and I am filing for H1B. Along with the H1B, I'm filing an H4 and EAD. Will the H4 plus EAD be approved along with the H1B? Yes, it will be approved along with the H1B. You may be filing the Quota case, or even if you already been counted towards previously, now you're moving from L1B to H1 and you already have an I-140 approval. If you file H1B and H4 and EAD, all three things will be approved. Can you elaborate? This question is coming from Sharath. Can you elaborate more on your earlier answer regarding ban with multiple filings? Sharath, what we are speaking about is people who have use the companies to file for multiple H1Bs when there is no genuine job opportunity. Let's say, for example, the guy is working with consulting company A and he's working with Coca-Cola as the end client. And then he's actually went and approached company B, company C, company D, company F, company G. And sometimes I've seen people filing from 20 different companies and then got their H1B selected with multiple of those companies. Now, the USCIS is revoking the application because this guy has filed H1Bs with multiple companies, even though the guy doesn't have a job opportunity. That's one reason why he may get, when he goes to the consulate, he may get a bar. Sometimes what happens is that this guy is working with company A, with end client as Coca-Cola, but the company A went through this friend's company and then got all the H1Bs filed from company B, company C, and company D, but the individual was not involved, and they filed the H1B. Still, that's considered to be fraud, and at that time, they can be questioned when they go for stamping, and they should be able to articulate it. Anybody where you have filed in a one fiscal year, you have filed for multiple H1Bs, so I would recommend strongly to contact a lawyer, because they published it on website that 90,000 people of the H1Bs filed in the fiscal year 2023, they have filed 400,000 applications with immigration last year. Now that's way, way less this year because multiple filings doesn't have much advantage right now. So yeah, but are there some genuine cases in those things? Yes, somebody is working for Apple and they got a job from Facebook. I understand it. Now, many people ask this question, well, the companies are not related. How are we in trouble? The question is not about company relation. It's about the genuine job opportunity, though. The company A has a job with Coca-Cola. If company B, C, D, E, F, G, H, I, J, L, M, N, O, P, R, Q, R are filing the H1B, where is the job? Where is the end client? That's fraud. Even though the company B all the way to company, all those companies are not related, if there is no job, they're filing the H1B, that is fraud. And if an employee is collaborating, agreeing, conspiring with these companies to file the H1B in the multiple, then that is considered to be fraud.
Kuldeep is asking, does CBP allow a person to enter with 1 month of H1 validity left? Yes, technically they can admit you in H1B status if your current approval notice is only valid for another month or so. However, I would probably carry a letter from your employer, a recently dated letter from your employer, confirming that you are employed with them according to the terms of the approved H1B application, and that they are preparing to file your H1B extension application once you arrive back in the US, so that you can provide that to the officer if they give you a hard time about having only a few weeks left.
There's no domestic stamping at this point of time. They did some pilot program. It is successful. They may come in. Now we do get asked this question, when is the stamping coming back? Believe me, on the day the stamping comes back, guys, we're going to come live. We want you to subscribe to our channel. So anything comes up, we will let you know, instead of just keep on coming every time and asking the same question. No, it is not there. The day it comes in, visa stamping in United States, we will let you know.
Arun has his I-485 pending for about 2 years and is getting ready to change employers and wants to know, does he have to file the I-485J supplement? No, you don't. So it's no longer required to file the J supplement proactively when you are changing employers. There were a lot of cases the past few years that there wasn't any proactive filing when you changed employers, and there wasn't a problem at all. All you need to kind of make sure of with your new employer is that they will be willing to fill out and sign the J supplement if you get a request for evidence from USCIS, or if you get scheduled for an in-person interview. They will most likely want to see the J supplement from your new employer that confirms the terms of your current job offer. So as long as your new employer is willing to fill that out and sign it if needed, that's enough. They don't need to actually file it proactively.
I'm working for a nonprofit organization. This question comes from Krishko. Once my I-140 gets approved for nonprofit, if I decided to switch to a profitable company, so will my I-140 start from the zero? Now, you definitely can port the date from a non-profit organization to proper organization. That's one thing that I will tell you. The second thing, let's say, for example, you're working for Texas A&M University as a physical therapist, and later on you move on to, let's say, Beverly, okay? And this is a for-profit company. And you move on to that company. Can the Beverly file the H1B extensions based on Texas A&M? Yes, they can. You don't need to have Beverly file an I-140. They can still use Texas A&M to file the H1B extension. Now, when you're working for Beverly, though, even though you have the I-140 approval with Texas A&M, if your spouse wants to file the H4 EAD, the Beverly can file H4 EAD along with the H1B, or you can privately file H4 EAD for your wife based on Texas A&M. Absolutely not a problem, though. Now, eventually, when you want to get the green card, now, since you're not working for Texas A&M, they may not be able to cooperate for you to get the green card. At that point of time, you may need an I-140 approval if the priority date becomes current and you want to file the 485 application, especially for Indian nationals, especially if you're filing an labor and if you're filing an I-140 in 2024 or 2025, your priority date, most probably it's not going to be current in the next 20, 30 years under EB2 or EB3. So you may not need an immediate labor and I-140 approval from the new company. But yes, the non-profit can be used for profit. Absolutely not a problem.
I'm seeing a few questions about concurrent H1B, H4, and EAD filing, and what are the processing times when everything is filed concurrently. So USCIS's general policy now is that if all three of those applications are filed together, they will be approved at the same time, or essentially the same time, which is whenever the H1B is approved. So if they're filed together in regular processing, then the H4 and EAD will be approved basically around the same time the H1B is. If they are filed in premium processing, then the H4 and EAD should also be approved within 3 weeks at the same time that the H1B is. That's been the policy for the last couple of years, and for the most part, USCIS has stuck to that. Every once in a while, we see an H4 case that is pending beyond the H1B approval, but those are pretty rare. And if you do have one of those cases, you can reach out and see if there is something that can be done with the premium processing unit, especially to make sure that gets adjudicated.
Question comes from my H1B change of status was being denied because I was unemployed for more than 90 days on the OPT period. He's saying 30 days more than, and they did approve the H1B, but they denied the change of status. Now that's what happens when you violate the status. And he's saying that if he goes for stamping, will he have any difficulty in getting the stamping? Let me tell you though, for the people under your circumstances, if I've seen 100 of them, I don't think so anybody got their H1B rejected. Maybe 1 or 2 of them, but 98% of the success rate is there. So you have very high success rate. But in the DS-160 form, there's a question, have you ever violated the status? You need to mention yes, and you need to mention that your unemployment was more than 90 days on OPT period. You need to mention that. Otherwise, that's going to create a problem. But as long as you mention that thing, I haven't seen any problem for the people who went for stampings.
We have a question from UK on what is the difference between an NIW petition that is self-petitioned versus an employer as the petitioner on the EB2 NIW. So if your employer is listed as the petitioner on your NIW application, then that I-140, when it's approved, it is still connected to the job offer from that employer. So if you leave that company, that employer can withdraw the I-140, and you may not have, a basis anymore to file the I-485 when your priority date becomes current, or you would need to, refile the NIW as a self-petition at that point, or get a new company to sponsor you. Basically, if you self-petition it, you have a lot more flexibility. Once that NIW I-140 is approved, and it's self-petitioned, then that's yours. Whether you change employers or not, you can move to any other employer, and that I-140 approval will still be safe. It'll be yours to use when your priority date becomes current, and you can file the I-485 based on it. Basically, the only requirement in that situation, since there's no job offer required, the only situation that needs to remain the same is your intention to work in the U.S. in the endeavor that was described in the NIW. Even if the employer changes, even if the kind of exact situation changes, as long as you are still planning to work in that national interest area, then that I-140 can be unaffected if you self-petition it. Your employer can still help pay for it if it's self-petitioned. If they are wanting to help pay for the filing or legal fees, they can do so, but you can still, if they are willing to, you can still be listed as a self-petitioner on that application, and it gives you a lot more flexibility going forward.
Question that's coming from Arti is, can L2 employer proceed with the green card application? Absolutely. You don't have to be an H1B. You don't have to be an L1 to have your employer file the green card applications. You can be an H4 EAD. You can be an L2. You can be, you can be in India not working. Still, the companies can file the labor and I-140 application. That's absolutely allowed. Anything else, Rebecca, for today?
No.
Thank you guys for coming in. For those people who did not get a chance to speak, my colleagues and my schedule is available online. You can block a time that suits to you. All of our lawyers' schedules are available. You can block a time. And don't forget that Reddy Neumann P.C. has a daily Zoom conference, which will be more interactive. Here, we just take the questions and answer. There, it'll be speaking, half an hour. We've been doing this service from 2012 to right now. It's been 12 years. Every single working day for half an hour, we take live questions on the Zoom call. Previously, it was a conference call. And from the time Zoom came in, we moved into Zoom call. So the Zoom link is provided at the bottom, and the timings are there, what timings you can come in. So you can join us and ask questions at that time. Thank you, Rebecca, for joining and answering the questions.